Good afternoon, everyone. Thank you for joining us today. Today's webinar is offered in partnership with the American Association of Clinical Endocrinologists, and today's topic is EKRA, the anti-kickback statute and the state all-payer rules, steps your endocrinology practice should take to stay out of trouble. And our presenters today are Robert Lyles and Paul Weidenfeld. Robert is a co-founder of Exclusion Screening and a managing partner at Lyles Parker. Robert's healthcare experience started back in 1984, first on the provider side, then becoming a lawyer as a federal prosecutor in the Southern District of Texas. He also served as the first National Healthcare Fraud Coordinator for all 94 U.S. Attorney's offices. Paul Weidenfeld is also a co-founder of Exclusion Screening and is a former federal prosecutor and National Healthcare Fraud Coordinator for the Department of Justice. As a recipient of the Nightingale's Outstanding Healthcare Litigator Award, Paul has an extensive background that includes over 50 trials and arguments before the U.S. Supreme Court. Please feel free to write in any questions as we move through, and without further ado, I'll hand it over to our presenters. Additionally, this presentation has not been approved for any CEUs or other credit.
Thank you, Andrew. Hello, Paul. Good afternoon.
Good afternoon, Robert.
We've got some interesting things to talk about today.
I think EKRA is really it's something that's a really interesting thing. It's new and it's kind of scary, isn't it?
It is. And you know, before we kind of get into a discussion of some of the problems that we're seeing out there that we know that prosecutors and auditors and investigators are pursuing, just for the folks on the phone, we probably just start to very briefly talk about, you know, what is EKRA?
Well, you know, EKRA is, it's a funny thing. In and of itself, it's part of a much larger body of legislation. And this is my favorite. So it's you ready for this? The Substance Use Disorder Prevention that Promotes Opioid Recovery and Treatment for Patients and Community Act, which they call the Support Act. They took some of the S's and U's and P's and so forth. What in the world?
I don't know. But EKRA is a small part of that.
It is a piece of it, and it was done to address kickbacks.
That's right.
It's right, isn't that right?
That's right.
And it was supposed to be originally just the kickbacks insofar as for recovery homes and patient swapping.
Sober homes, substance abuse treatment centers.
Right.
That's right.
But what happened?
Well, what happened was those organizations were having these relationships with laboratories that prosecutors and Congress was very concerned about. So they threw labs in the mix. And essentially what they did was they said, you know, we've got a real problem with these improper business relationships between the sober homes and treatment centers and the rest of it and labs. Okay, we'll get the urine drug tests and all the rest of it. So the point is, what they said was, we're going to take the federal anti-kickback statute and essentially take those concepts and apply them on the private side.
So, you know, it's the whole thing. Actually, the labs, the inclusion of the labs, I have heard, was like a big surprise.
It was at the very end they threw it in.
It was like, boom, it was there, it was. And then all of a sudden it was passed, and they were looking through the fine print, because that act, that held the language of the name of it takes a page and a half. It was like hundreds of thousands of pages, and then they added the labs. And that's like the stink bomb, because everybody that's listening to this, and everybody and all of their partners and all the relationships they have, everybody deals with labs.
That's right. And there is no requirement that the labs are only dealing with the sober homes and treatment homes. In other words, anyone, including endocrinologists, who have a business arrangement or business association with a lab, has to be very careful to make sure that that business arrangement does not violate the federal anti-kickback statute and also the EKRA provisions, which essentially are a federalized prohibition of kickbacks with respect to private payers.
So that's is that what they mean by an all-payer?
That really is kind of a new federal all-payer statute that prohibits kickbacks.
When I hear all-payer, that means it extends to any insurance company, anybody that makes a payment?
Most of the time when we talk about all payer statutes, we're talking about on the state side. And, that's kind of one of the things that we'll be talking about today is the fact that there's always been prohibitions in most states that said that you can't give kickbacks in order to induce referrals that are paid for by private payers. That's always been the case. But the states haven't had the resources to prosecute those cases. So in recent years, we've seen the federal government bootstrap these cases using the Travel Act and that type of approach. And now they don't have to use the Travel Act anymore because EKRA essentially gives them this new federal tool to deal with kickbacks that have been that are involved with private pay reimbursement.
So to put this thing in a quick little frame, what we had was an attempt to deal with a very serious problem, right? The opioid problem. Okay.
Yep.
They added and they wanted to deal with referrals in that, and they were targeting that. But all of a sudden, the addition of clinical labs to this means that one provision involves a whole new world, like literally the entire medical provider world.
It really does. It really does. And there are some providers that are more heavily hit than others, such as pain practices with the drug urine tests. So that's something that you kind of have to worry about. But let's kind of talk about
there we are. That's the frame.
Yeah, let's kind of just look at what are we seeing out there in terms of enforcement right now.
Okay.
And we're seeing a lot of very interesting things. The use of patient brokers, not really happening on the endocrinology side, but we're seeing it on the substance abuse side. But the involvement of telemedicine scams, we're going to talk about that a lot today too.
Is that real? And that stems all the way to the telemedicine. You wouldn't think that.
It really does, because they are getting docs, including endocrinologists, who are looking for some kind of side gig, if you will. To sign, these companies are getting them to sign up to provide telemedicine services, and unfortunately, in many cases, the docs don't realize it, but they've been brought into a fraud. So you have to be very, very careful.
That's what you're saying.
We've got kickback situations by marketing folks, gifts to patients, illegal patient inducements. That's something that impacts endocrinologists, of course. Identity theft. Exclusion screening, always a big deal. Nobody's screening. That is the single number one risk area that most of the folks on this phone are not looking at, that can cost them hundreds of thousands of dollars if they're not careful. Billing for services of unlicensed individuals, failure to provide proper supervision, billing for dead people. We've talked about that before in the past. It comes up again and again and again. And then failure to screen. Moving back just real quickly, billing for the services of unlicensed individuals. That's also kind of kissing cousins to billing for non-credentialed providers under your name and number. We're going to talk about that too today.
Well, that is like something that is a problem that will not go away, and I'm glad we're addressing that today.
Okay, so let's start out. What we're talking about today really is kind of business arrangements and the types of business arrangements that can get you in trouble, frankly. Because whether you're talking about the kickback side on the Medicare, Medicaid, Medicaid Advantage side, or you're talking about private pay or patient inducements, all these things, involve some type of business arrangement. And one thing you need to do before you sign on to any business arrangement, of course, is you need to kind of have your lawyer, frankly, run it through the traps and see, is this arrangement, does it qualify? Does it meet the requirements under the federal anti-kickback statute for a safe harbor, or under START for an exception, or now under EKRA? They also call them exceptions, by the way, which is a little confusing. But they should have been consistent, I think.
And in addition to that, in addition to those three levels that you just mentioned, there are within the states, within the Medicaid units themselves, and there's an attempt to promote kind of the use of programs where you share for the relationships of patients. In other words, so to get away from individual payment, but towards anyway, so
Yeah, so the relationships here and the business arrangements that we have to worry about. I mean, some of the things you want to look at, you really, before you sign, and this is the bottom line, guys, before you sign up, because there's a lot of folks that are going to approach your practice and they're going to say, this is the best thing since sliced bread. You can make a lot of money doing this. We can be business partners. Don't sign anything without having your attorney look at it first. And do not, and they will tell you, because we've had clients that they told them this. They would say, oh, but it's okay. You don't have to worry about having your lawyer look at it. Our lawyer already looked into it and it's fine. Well, you know, literally every time they've told me that, I've asked them, I said, go back and ask them if they think it's fine and their lawyer did an analysis, ask them if they'll share a copy of that opinion letter so that we can look at it ourselves. To date, not a single one has ever had an opinion letter that they could share. So in other words, these folks that are trying to get you to sign on to whatever scheme it is that they're involved in, they'll say anything to you.
And it may
Be
not
careful.
Be, and it may not be a scheme.
It may not.
It may be something that somebody, you know, a lot of non-healthcare lawyers will review a relationship and say, oh, that's okay. And we have seen this many, many times, but they don't understand all the different levels of review. And so they don't understand the kickback statute or Stark in particular. And they say, oh, well, that's fine. And I've seen it many times where even healthcare lawyers, supposedly healthcare lawyers, will write these opinion letters, but they won't really do it in an opinion letter. They'll put it in an email. And all you've got is this email.
Got to be careful. But your point, though, I think is especially important, and that is, you know, a lot of times these docs, they'll go to the lawyer that handled some other action for them, and it can be anything, and they trust these guys. And you know, the fact is, I respect those lawyers. I don't do what they do, but they don't do what we do. The problem is that many of the marketing business practices, many of the compensation arrangements that are perfectly legal and acceptable in other industries.
No, that they're the way business is done.
That's the way business is done. That's right.
In other industries.
Are illegal in healthcare.
Right.
That's the problem. Okay? So before you sign anything, guys, I don't care if it's a lease or any other kind of contract, have your lawyer look at it. I'm not saying it has to be me or Paul, but have a health lawyer that you trust look at it.
I guess the maxim that you'd always keep in mind is, if it looks too good to be true,
probably is.
Yeah,
that's exactly right. That's exactly right. So let's kind of get into it. We've talked about the business arrangements. We've talked about, let's get into the 800-pound gorilla, the federal anti-kickback statute.
Right.
Now, everybody knows what a kickback is. What's a kickback, Paul?
I give you something in return for something illegally.
Or, yeah, you're giving me something of value to induce a referral or a recommendation or business.
Well, that's a healthcare kickback.
That's a healthcare kickback. Right. That's exactly right.
You know, a kickback implies that it is illegal, right? So you can't ever, and in healthcare, the strange thing about it, the unique aspect of healthcare is virtually anything that that any remuneration that I give you in return for any sort of referral.
And that's a crazy word, remuneration. What does that mean?
Well, that is
something of value.
Anything of value.
That's right.
And we have seen in the kickback statute, now people will see in Stark, for instance, that there is this minimum, or that there is an amount that's acceptable. But Robert, is there any acceptable amount as a kickback?
There is not. And this is really important to remember. You know, all the time, I have clients that will call me up and they will say, well, I thought that it was okay if we give something, or if we spend up to anywhere from, and they'll give me some number, anywhere from $100 to $250 a year.
Yeah, I've seen $300 a lot for whatever reason. That seems like probably not an unreasonable amount, except, well, that's
you can look at the statute. There is no de minimis under the anti-kickback statute. So theoretically, you know, anything that, let's say you're an endocrinologist and it's the end of the year and you want to send out some Christmas gifts to say thank you to all these family practice docs who send you business, okay? Is that a problem?
Well, if everybody gets the same amount and it's small, it would be remuneration. Now the question is whether it's in return for a referral. So that if you gave all the docs the same amount, but what we've seen in some situations is that whoever gives you the most referrals gets the biggest prizes.
Yeah.
And then it starts to look like something different.
Well, that's, you're a very practical lawyer, Paul. But the bottom line, though, is technically that fruit basket that costs $25 is a violation.
Well, it's remuneration.
It is. And, when people tell me, they say, well, it's not intended to induce business. Really? So is he a stranger? No, because short of being a stranger that you just picked up the name out of a phone book and sent it to, there's a reason you sent that fruit basket to that doctor. And I guarantee you it was to curry favor. Even if they didn't send you referrals this year, you want them to send them to you next year. So
I can't argue with your logic. It is absolutely on point, and it is true.
But your point is, no prosecutor with their salt is going to go after you for a fruit basket.
Right. As long as it's the same fruit basket as everybody else.
Yeah, I disagree with you there. I think it's period. Well, anyway. But you and I actually handled a case a bunch of years back.
Yeah.
Where the government did go after them because they were giving out liquor
and tickets to March Madness, but Midnight Madness, free tickets.
Yeah.
They said, well, they're hard tickets to get. They were free. Nonetheless,
the government went after it. They included that as part of a overall false claims case that was bootstrapped. And those are kickback allegations that, of course, they bootstrapped into the False Claims Act. Now, one thing before we move on from this slide, I want to point out, and that is that last year they actually increased the penalties and the time period that you can go to jail for violations of the statute. From the penalties went from $25,000 to $100,000, and the time you can go to jail went from 5 years to 10 years. And that's significant, and a lot of folks haven't really kind of picked up on that. But it's important to remember this is a criminal statute.
Now, the one last thing I will say on it, and then we'll move on quick, is that the government does not have to prove that you have knowledge that you were violating the kickback statute. Because it used to be, well, I didn't know that was the problem. However, they don't have to prove that, but if they just prove that you knew it was wrong, that's enough for the government to prove.
Now you're talking specifically about that change that happened as part of the Affordable Care Act.
Right. That's
where it no longer requires that you have actual knowledge or specific intent in order to have a violation.
Right.
Which, frankly, I personally have a real problem with, just because, I think it flies in the face of 250 years of American jurisprudence that they can charge you with a criminal statute that you had no intent or specific intent or actual knowledge to violate.
Right. And so what the pushback on that most healthcare lawyers will use these days is they say that, well, you have to at least prove that he knew something was wrong about it. Because even as in a general intent statute, we're getting into legal hyperspace here, but they have to know that it was wrong. And the prosecutors, frankly, they don't take that view. They say, no, we don't have to prove that he knew it was wrong. We just have to prove that he knew that he was giving and getting in return, and that's it.
And that's the problem.
And that is a problem.
That's a problem. And that's why it's so important, once again, that may work in regular business, but it doesn't work in healthcare. Next slide. Okay. Now, the whole purpose of having this slide up here that I wanted to kind of point out, and we're going back to the Affordable Care Act again. One of the primary provisions in the Affordable Care Act that from a the Affordable Care Act, of course, is extending the ability of people to sign up and be covered for health insurance.
Which may be gone after not too long.
Well, who knows? But from an enforcement standpoint, one of the most important provisions in the statute is the fact that the government, under the Affordable Care Act, there was a provision that says that the government can pursue a violation of the criminal anti-kickback statute as a violation of the Civil False Claims Act.
Yes, a very close friend of mine was very much involved in the civil division in creating this and extending the False Claims Act by saying, well, if you violate the kickback statute or STAR, then those violations taints the claims and makes them False Claims Act violations. And so they actually put that into the statute in the False Claims Act. They made that actual law, which is really a stretch beyond a stretch. What happens is that they end up enforcing a criminal statute through the False Claims Act.
Yeah.
And since 95% or a greater number of the False Claims Act cases that are pursued by the government, and this is just a quick aside, are QUETAM or whistleblower cases.
We're going to talk about that in the next slide.
Well, and what we find is that the whistleblowers are driving healthcare fraud enforcement, which is, in my mind, insane.
Well, and I will tell you, just from it's not necessarily a bad thing. Arguably, without that provision, if you had a violation of the kickback statute, the government only had one choice, and that was to go after you criminally. Whereas we're seeing a lot of cases these days where there are allegations of violations of the kickback statute, where the government's not going after them criminally, they're only going after them civilly.
Yeah. Well, I think that the False Claims Act itself is something that has long-standing value and has been proven. However, when it drives your enforcement criteria and your enforcement, your healthcare fraud enforcement, then that's not the way that healthcare support ought to be enforced. That's my personal view. And it was my view, by the way, back when I was doing these cases.
I know. Next slide. Okay, and you talked about this. I put the False Claims Act up here because even though today we're talking about kickbacks, the fact is most of the kickbacks these days are being pursued eventually under the False Claims Act. You made the point, very important point, that almost 90% of all the False Claims Act cases being brought, okay, are being brought by whistleblowers.
Absolutely. And I've also done a long-term analysis on the monies that are recovered, and it's about $2 billion a year by the healthcare, $2 to $2.5 billion every year for about the last 10 years, and well over 95% of the recoveries are based on QUETAM lawsuits.
It's a serious business, and the reason why this matters, of course, next slide. The reason why this matters, of course, is these whistleblowers. One thing to remember, another provision of the False Claims Act, of course, and related to the Affordable Care Act, is, of course, under the Affordable Care Act, if you have an overpayment that you identify, if you don't report it and return it within 60 days, but that's really been extended under the Federal Register, additional 6 months out there under certain circumstances. But if you don't, those overpayments now turn into violations of the False Claims Act.
Because the logic is, if you have an overpayment and you know about it,
and you don't turn it back,
wait a minute, you're keeping something that you know isn't yours, and the government really, quite properly, will not accept that, and that becomes a false claim.
But this is really important because now all of a sudden, you're talking about essentially anyone in your endocrinology practice is a potential whistleblower.
Well, see, that's the thing. The thing about whistleblowers is they are, in almost all instances, not 100%, but mostly, they're employees of someone who they are reporting for having committed false claims. Now, the government only pursues maybe 20 or 30, 10, 20% of the ones that they get filed, but so they're pursuing claims by insiders, people who are there. And there is, of course, the retaliation claim, right?
Right.
So that when someone is fired, they will often say, I was fired, and you fired me because I made allegations that you were doing wrong. That's a problem.
So we've got this one silo of False Claims Act violations that really have matured out of kickback issues.
Yeah.
But then we have just pure False Claims Acts and our false claims. And the way that comes up, of course, is if you knowingly submit or cause to be submitted a false claim to the government. And you may say, Robert, I would never knowingly submit. Well, the problem is knowing, really, knowledge has three definitions under the statute, doesn't it?
Yes, it does.
It's got actual knowledge, which is what we all think of, reckless disregard, okay, and deliberate ignorance. Deliberate ignorance, I think, is kind of like an ostrich sticking their head in the sand.
Right.
Reckless disregard is kind of like gross negligence.
Yeah, reckless disregard, I always thought of as someone, if you can't, you're looking at it, you actually see the ostrich puts his head under the ground and goes, no, 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 no. The reckless disregard is you see the memos and you just kind of go, well, that really isn't important. That's really not happening. I don't believe that guy. I'm not going to investigate that. So they're hearing it and they're just disregarding it without, and whereas the other one is really just nah, Sergeant Schultz kind of stuff.
But if you look at the damages and the penalties are involved, if there's a violation, of course, you're subject to penalties plus treble damages. So even if it's a $100 claim, on the low end, if it goes forward and is proven, they're going to hit you with $11,000 and change up to almost $23,000 per false claim, plus 3 times the $100 overpayment.
And the problem with false claims were originally supposed to be, those numbers were because they were not in healthcare where they were linked to individual submissions. Here in healthcare, of course, you make every
time you hit enter.
Right. Every practice makes 1,000 claims a day.
When I first started working in hospitals, of course, a long time ago, literally we would get claims together, bundle them up in a big package, right, and send them off. We wouldn't mail out each individual one. We'd send it off in a big box, right? Well, it's interesting because the case law has developed that box full of claims is one claim. That's it. But that's not how we submit claims anymore, is it?
No.
Now, every time your biller hits enter, that is a claim, a separate claim that can be subject to penalties and damages.
And of course, even though you don't even actually submit claims anymore, right? I mean, because your data gets pulled by the billing software and so on and so forth, they don't deal with it. They don't worry about those niceties. They'll just look at every CPT code. They'll just consider it, that's a claim. Period. End of story.
Next slide. Okay. So we talked about the fact, you got 60 days. You have to turn it in. And, I will say that the Affordable Care Act, when they came up with the new 60-day rule saying that you have to report and return an overpayment within 60 days, they also issued guidance in the Federal Register that says if you do identify a problem, if it's a one-of, that's one thing. But if it's something that John, your coder, it turns out he really just never really got a good handle on modifiers, and he's been messing up modifiers, you're going to have to go back and check up to the last 6 years. That's what they expect you to do.
Right. The thing is that there is now this obligation, and there may always have been, at least the government would have argued that there always has been, but now we know for certain, there's an obligation of investigation.
Yes.
You can't just say, oh, John was messing up that month, and so we're going to refund and rebill those claims that he submitted under that CPT code that he did wrong, and that's it. No, you can't do that anymore. You've got to look and see how far back that goes. You've got to look and see, was he operating under instructions from his supervisor, which means that maybe 2 or 3 other people were billing it that same way. You have an obligation of investigation. And if you don't fulfill it, then all of those claims really become problematic.
And once again, you may have someone on staff that recognizes that all you did was repay that one claim that John did wrong, but everybody in the place knows John's been doing it wrong for the last 6 months.
Well, I've seen lots of places where they pretty assiduously will have, regular audits, kind of probe audits to see if something's wrong, right?
Yep.
And that's a good thing to do. But then when they find things in that probe audit, all they do is deal with the things they found in the probe audit, and that's where they run the risk. They don't dig after that, and frankly, you got to.
You have to go back. Okay. Now, we've talked about the kickback statute and the fact that
I give you something in return for referral. That's wrong.
And it's so broad.
Right.
It's so incredibly broad that Congress said, you know what? We've made it so broad here, but there are some situations, some business arrangements that if you meet certain requirements and certain safeguards are in place, even though it's a technical violation of the statute, we're going to say that that won't constitute a violation. And they refer to these as safe harbors.
Or they refer to it as the Lawyer Support Act of 19 whatever.
The point is, safe harbors are very complicated, and it's not something that you ought to be doing the analysis on yourself.
Right. So then you got to go to lawyers to evaluate whether or not it meets the safe harbor. And if any of you who are listening have ever been involved with looking at those analyses or something, you know what we're talking about. It gets really complex, and then often will sometimes result in requests to the Office of Inspector General for them to make a determination, which takes a year or more to happen.
Next slide. Okay, and that leads us up to EKRA. Now, as we briefly talked about, as we first started out today's webinar, EKRA was really there to deal with these abusive business practices that are being engaged in by sober homes, labs.
What's a sober home?
A sober home is it will actually show you the definition in the coming slide. But that was really why EKRA was passed. But the reason, again, why it applies to endocrinologists is because there is no requirement that the lab businesses or the lab arrangements, the laboratory business arrangements that are involved,
right,
have to have anything to do with sober homes or treatment.
That was the intent, to really focus in on these, because this is how they saw these as the primary problems, or if not the significant problems with respect to the opioid crisis. They were trying to home in on it and deal with them, and all of a sudden it all exploded. It's like a mushroom cloud, as we will talk about.
Now, one thing to kind of point out about EKRA, there are significant penalties that have been assigned. You can be penalized up to $200,000, which of course is twice what you can be assigned under the federal anti-kickback statute, and you can go to jail for 10 years.
And 10 times the amount that I made the first year I was a lawyer.
There you go. All right. Now, remember how we talked about how the federal anti-kickback statute, which of course is related to and covers Medicare, Medicaid, and other federal health benefit programs, how there are a number of safe harbors, and those are those situations where Congress recognizes that, it may be a technical violation, but okay.
Which we didn't really talk about, but the most common one is if he's a full-time employee, it can be an okay arrangement that's not other
certain requirements.
Right. And so forth. So we didn't talk, but there are quite a few of them. However,
EKRA they have a total of what they refer to as exceptions, 8 exceptions. Okay, 2 of which really are something that endocrinologists would probably want to know about.
Well, before you get into that, let me just ask you: if you met a safe harbor, a safe harbor to the anti-kickback statute, right? Mm-hmm. But you don't meet one of these safe harbors, are you okay because it's not a kickback in the first place?
No, 2 different sets of kickbacks.
So you could
different analysis.
So you could meet all of those requirements. You could paper it up, and it could be just fine.
That's right.
But you've got to do a whole new layer of analysis.
And in fact, the analyses that they require, for instance, here you talked a moment ago about the employee safe harbor under the anti-kickback statute. Okay, yep. And the way they treat employees under the anti-kickback statute is very different than the way they treat independent contractors, for instance. Okay, here, employees and independent contractors that both have a bona fide contractual or relationship with the employer, they're both covered under the same exception, and you have to be very, very careful because that employee or that contractor's payments It can't vary by the number of individuals that they refer, can't vary by the number of tests or procedures performed, or the amount that they expect to receive from it. So, and this is on the private pay side, remember, okay?
As well as, is this just the private pay
Yes.
side?
Yeah. Yeah. So, so next slide. All right. Also, of course, they've got the waiver and discount issues, you know, of when can you waive co-insurance and co-payments. That's pretty much it. Now, you know, one thing that there are, of course, 6 other exceptions, none of which really, at this point, have a lot of implications for endocrinology practices. But the important thing to kind of keep in mind here is there are no cases out there. There's no case law that we can look at. We don't really know exactly how these exceptions are going to be assessed, because unlike the anti-kickback statute, where the safe harbors are really put together and interpretations are done by the Office of Inspector General, okay, these exceptions, all right, you have to be very careful, because the Attorney General is the one that makes the decisions about the exceptions here. She's supposed to consult with the Secretary for HHS, but the responsibility for making determinations regarding the scope of these exceptions and how they're going to be applied and how they're going to be prosecuted, it lies with DOJ, not with HHS OIG.
So I don't recall, do they have that same process of notice and an opportunity to respond?
Well, now you're talking...
In terms of making those...
yes.
They did.
Yeah, they would still have to go through the administrative rule procedure making requirements.
For DOJ?
Yes.
I don't even know. I was in DOJ for too many years, and I don't recall them even having such a process.
Well, this is something new. Yep.
My goodness. And so it's interesting that whereas a direct employee is treated differently than an independent contractor
Under the kickback statute.
under the federal and the kickback statute.
Right.
But under EKRA, as it applies to the non-federal payers, it doesn't.
That's right.
And one thing about EKRA is, although it was supposed to, this is just something for endocrinologists to think about, although it was supposed to just deal with the opioid crisis, federal prosecutors, once they see an ability to use a statute broadly, they don't really care about what it was supposed to deal with. For instance, in identity theft, which we know is about stealing identity, right? And that was what it was supposed to deal with. Well, they use that all the time in healthcare cases with the use of when
any kind of submission of an improper claim.
Right.
They say, well, you didn't have the authority to use that identity in that fashion.
So don't think that just because it wasn't supposed to be dealing with you, that they won't use it.
EKRA is still the Wild West. We don't know how they're going to handle it, but we know that it's already shaking up the industry. Okay. Now, you asked, what exactly is a
Sober home.
A sober home. Well, a recovery home, a shared living environment, it's the same as a sober home. You know, it purports to be free from alcohol and drug use. And that's the statutory definition out of EKRA. Okay. So that's where people go. Once they've kind of gotten stabilized by the substance abuse treatment center, then they would go to like kind of a halfway house, if you will, someplace that they can live with other people who are also staying away from alcohol and drugs and really kind of reintegrate back into
society or wherever they started from.
Without having those challenges in front of them.
Right, which makes perfect sense.
Yeah.
But
no, there's no but that doesn't apply to the folks on the phone. The only one that really applies on the phone, of course, is the definition of labs, which is everything from a clinical laboratory, any kind of clinical laboratory for that matter.
So they were trying to break this cycle of going from recovery to sober homes and then back to recovery units, and then this is the cycle they were trying to beat. And the labs are a part of that cycle because they're either providing pain pills on one side or pills or medications on the other side while they're in the sober homes or the recovery homes to help them break those habits. And so the labs, I think they were seen as sort of the link between the two, the sober homes on the one hand, or the recovery homes, and the treatment centers. So that's why the labs were targeted, I believe.
Well, that and the fact that the labs, unfortunately, as we've seen just recently in a number of genetic testing fraud cases, okay, the labs have in the past, before EKRA, had all kinds of business relationships with marketing companies that they would get these marketing reps would go to senior centers and other types of places, get these seniors to or even private pay people to sign up to have genetic testing done, and then they were paid a percentage from the labs.
So they received the labs in a number of different ways of being sort of, and there were a number of labs that were not really dealing properly with
That's right. That's right. And, you know, it really has been before EKRA, even though, in my opinion, it was already against the law, okay, under the state all-payer statutes. And now you and I have had this discussion of whether or not it was even covered under 1347. You know, because just general healthcare fraud, depending on the facts. But the fact is they weren't being prosecuted by the states.
Right.
Okay, so EKRA was really an attempt to kind of rein in abuses being committed against the private payers. Okay, and here's a couple of the all-payer statutes. You know, Massachusetts and Texas. You know, they for a long time it's been against the law in many states. This is just two examples for you to provide anything, any type of remuneration in order to induce a referral, even if it's paid for by private pay.
And by the way, I mean, the healthcare statute 1347, which is what you referenced, it does specifically include for a criminal violation.
Yes.
It does specifically include any payer, whether not just Medicare, Medicaid, CHIPS, and so forth, but any healthcare payer. So it does include them.
It does, but you and I,
it's very.
The question
rare.
is whether or not it would cover a kickback.
That is a good question because
I've never seen a kickback case prosecuted under 1347.
Agreed.
And I think it's because of the language that's in 1347.
I agree. But it could, but I don't think they never have. We never did it,
No.
certainly. And I've never known anyone to do it.
Yeah.
Too big a stretch. But now.
Okay, so let's look at some of these risk areas and these are risk areas not just for endocrinology practices, but for all physician practices. We'll go through these fairly quickly because I know we're only have about 20 minutes left or so. Overutilization. You know, there was a case in Virginia. You know, this was on the urine drug screen side. You know, one of the things that the government looks at these days is how often is a physician ordering these screening tests, you know, and I feel sorry for folks working in pain because, you know, you and I have handled a number of pain defense cases. If you don't screen enough, they think you're being negligent,
right,
and it's a risk to the public. But if you screen
too much,
right, then they think it's abuse and overutilization.
And because no one wants to prescribe pain medication anymore, and it all falls or not nobody, but so much of it now falls to the specialists, then they do a data mining and go, oh my goodness gracious, you're 5 times larger than anybody else in your area. Well, it's because I'm the only one doing it in my area. Nonetheless, so you need to be careful of that sort of thing.
Right. The next one, paying more than fair market value. This is kind of an interesting one. In this particular case, this individual was being paid, I believe, as like a medical director, okay, but they were paying her far more than fair market value, okay, for what she was doing. And the government came in and said, well, they're really basing the payment on how much she can generate in terms of these ancillary services that she's ordering.
Right.
And that's not how you can do it.
And people would used to say, well, I could do that because, you know, I don't have any federal payers. I'm purely private now. That no longer washes, right?
No.
And I've heard that in a number of occasions.
No. And this, you know, could be, this is an example of a case, so it could be pursued as a kickback case, okay, or an EKRA case if it was private, but also it could be pursued under 1347 because she's ordering medically unnecessary services. Right. So this is a good example of a case that could go under 1347 or the kickback statute. Okay. Distributing controlled substances without a legitimate medical purpose. That's a big, the top two there are opioids, essentially.
And, harking back to the second risk area, paying someone too much. The other thing is a lot of places have relationships with labs because they order so much, they order a lot, and then the lab person and then so there's somebody to actually rent space to the lab to facilitate.
It gets pretty messy. You got to be careful.
You got to be very careful with those. It's okay under certain parameters, but you've got to really have a lawyer look at that, make sure it's fair market value, make sure that person isn't doing all kind of extra things.
Answering the phones for the practice.
Exactly.
Okay.
That sort of thing. And we apologize for that interruption by our sponsor.
Yeah. Okay. Healthcare fraud. We've kind of talked about the healthcare fraud statute. It's fairly broad. Your whole point was it covers Medicare, Medicaid, and private. In this particular one, it was an interesting case. It was another opioid case, though, where the employee was being paid. They were paying for pre-signed prescriptions. So obviously you can't do that. Next. Okay, patient inducements. Now this is something. There's at least two patient inducement statutes here we want to kind of cover. Both of them are federal, but you have to understand most states also have a prohibition against patient inducements. So at the state level, you have to also worry about that.
I've seen 2 or 3 recently patient inducement. I hadn't really seen those before, but that they're extending in all directions.
And this is one that really is problematic because on the one hand, you've got the OIG guidance that talks about how under certain circumstances you can give something of value to a patient that is worth no more than, I think it's $15, or they may have gone up a little bit, worth for a total of like $75 a year. The problem with it, the problem with that though is, OIG essentially says, well, we wouldn't pursue civil monetary penalties as long as it meets these requirements, okay? But that still doesn't mean that it's not a violation of the federal anti-kickback statute.
And they're particularly concerned about patients who will bring in other patients. So that's really where the cases that I've seen is you induce this patient in order to sort of induce others to follow.
Folks at the senior center.
Pied Piper cases.
That's right. Next slide. Okay. Failure to screen. We talk about this all the time. You have to, by law, if you participate in Medicare or Medicaid and other federal health benefit programs, you're supposed to be screening your employees against the state and federal databases. Currently, I believe, Paul, there's 43 in all.
Yeah, I believe that's it.
And you're supposed to do it every 30 days.
Medicaid has been on that for a decade now. They've been requiring it. Medicaid on the OIG side, it's only slightly, it's about the same really. Actually, it's been since, 2013 for sure, every month. So you've got to do it, and the states are really, their requirements can be pretty rigid. And everybody says, oh, it doesn't matter. I don't have any, a lot of times I don't do Medicare or Medicaid. Every private payer has some requirement that says we don't pay for services provided by excluded individuals.
That's exactly right. That's exactly right. And, if you're an endocrinologist and you're getting referrals, you need to make sure that the referrals you're getting are from doctors who have not been excluded.
Well, that is a new risk area. They have really, they're expecting pharmacies to make sure that the doctors haven't been excluded, and that the doctors who are getting referrals, the whole link in the chain, you don't get to say, oh, I just worry about my little world. Anything that comes to you or that you send to.
That's right.
If you send someone to a pharmacy where the pharmacist is excluded.
Yeah. And you got to be careful. I mean, this is the same risk area. It's not enough to do a background check. I mean, there are literally companies out there who you can check them out yourself for the right amount of money. They'll come up with a resume, a work history, employment history, where you've lived. It's very impressive, really, what they can do. But that's just another product of the internet that we didn't have 20 years ago.
They'll get you referrals. They'll get you, how many referrals do you need, and what zip codes and what area codes do you want? What
references?
That's what I meant. References. Where do you want them to come from, etc.
Yep. Okay. Improperly using the patient's identity. That's aggravated identity theft. We talked about that. We talked about the federal kickback statute. Just real quickly here. Telemarketing fraud is being pursued. There are companies out there right now, and this particular case that we were talking about, or that this is talking about, this company, this telemarketing company, what its job was to gin up referrals for a home health agency. And on paper, remember, this is an independent contractor, so you cannot have a compensation scheme that's going to vary by value or volume, right? And on paper, it didn't, okay? But in real life, they were compensated for every patient referral that they got.
So my thoughts on telemarketing are this. At first, it was sort of like advertising for lawyers. They didn't want it to happen, and they put the stop on it. But it's a tidal wave that you can't stop. However, there are a lot of forces that really resist, that are there to resist and resent its incursion into their territory, particularly all the medical societies and each state and the medical boards and so forth. So they really are pushing back hard on them, although it's a wave coming. And the reason I bring that up is many doctors, you guys guys and gals may be included, will be approached or may think about, telemarketing. You can reach a broader market. It's a good idea. People get to stay at home. There's a lot of good things about it. My only advice is, because there is so much pushback against it, be very, very careful about any participation in those telemarketing practices. They may be perfectly okay. They can be structured, as far as I know, to be perfectly okay, but they also are sometimes structured in a way that's pretty loosey-goosey. And like as Robert said before, when someone comes up with a contract, says, "Oh, no, my lawyer said that if you do this, it's perfectly okay." And we've seen a case like this, Robert, and we said, okay, well, let's see the contract. Let's see what he says, what that opinion letter is. They don't want to share that right now.
That's right. Now, this is another big area, telemedicine fraud, as opposed to telemarketing fraud. There's that big $1.2 billion case that just came down, where it was a $1 billion DME case. And it had everything. It had the DME companies, it had telemarketing companies, and it had doctors involved in telemedicine. Now, the problem is I'm not saying that all telemedicine is fraud, okay? There are a number of companies out there that are, in fact, providing legitimate services. But I'm telling you on the phone, if you are approached, if you're a physician or a nurse practitioner, or if you have prescriptive authority and you're approached by an organization and they want you to do evaluations by phone, understand you have to be very, very careful, because there have been a lot of doctors that have gotten wrapped up in these situations that they weren't expecting. They thought everything was on the up and up, and it turned out that it wasn't. You've got to look and see. What are some of the indicia of problematic contracts, if you will? You got to be very careful. We've seen a lot of situations where they hired doctors. What happens is, and there's 1,000 ways it can happen, but these telemarketing folks are folks, whether they're going to senior homes or group homes or wherever they're going, they get a list of people who theoretically are potential candidates for a certain product or service, such as compounding medication for pain. We've seen a lot of that. They get all this information and they share all this information with the doctor, and they say, "Doctor, you need to call this patient." Well, the doctor doesn't know where they got the list from. He hadn't been hired to look into where they got the list from. He calls the patient up.
Or the patient calls him.
Does an evaluation, issues a prescription, okay? Well, then that prescription ends up going to a lab, possibly, if it's a compounding lab, and they bill literally, thousands and tens of thousands of dollars for some of these compounding pain creams. And we've seen a lot of fraud in that area.
I think that the buzz, as soon as you're being asked to do something on a one-time basis, that's when the red flag needs to go up if you're a physician. If they're asking you to see this person in order to fill in the blank, make a prescription, make a referral, do a certificate of need, that's when the red flag goes up. Now,
and that's what the government's going to say. The government's going to say you didn't really have a legitimate bona fide doctor-patient relationship.
Right. You just, you were asked to do one thing, and we don't even need to treat it as a bona fide relationship. That's really where you pay. Now, even where that's not happening, again, because of all those forces that are sort of pushing against it, you need to be very careful. But in particular, if you're asked to do a single one-time evaluation, visit, whatever, with an individual person, that flag ought to be waving.
Now, one of the other things to kind of keep in mind is, if you're doing a legitimate telemedicine evaluation, you're going to be billing for that service.
Of course.
Okay. Most of these bad ones, okay, they're not. The doctors are being paid, per evaluation or per month, okay, and the doctors aren't sure who, if anyone, is billing for the evaluation itself. All that they know is they're issuing a prescription, which ultimately is resulting in the issuance of a DME device or a lab compounding cream or something like that. So, is it possible that you could work for a group that has a group number and they're billing it that way? Yeah, that's possible, but just be careful, because if someone tells you they're going to give you X amount a month to handle up to so many calls, you need to figure out exactly who is being billed.
Yeah, what service are you actually providing? I mean, are you really doing a legitimate evaluation?
And also keep in mind that the telemedicine rules for coverage and payment are different from state to state.
Right.
And you may be in Oregon, and they may send you a referral from someone who's in Colorado. Well, if you're not licensed in Colorado, I can't tell you if that's a legitimate order or not.
That's where the whole basket of worms that I was referring to before begins. Right? What medical society is in charge to begin with, and it just goes downhill from there.
That's right. Okay. We talked about this before. Hopefully, no one on this call is going to be audited or investigated, but it can happen.
Most people will be audited, hopefully not investigated.
If the FBI shows up, though, Paul, what do you have to worry about? What is all this about?
Well, this looks like an FBI 302, is it not, Robert?
It is. And a 302, what is a 302?
So that's the summary of interview that one of the agents, there'll always be two, that the agent who's not asking the questions will be writing down as what occurred during the interview. Now, as Robert will point out, that becomes a matter of fact, doesn't it?
It's very, very scary, really, because when the FBI comes in and interviews you, okay, you're right. They're going to have two agents there. One's going to be talking, one's going to be writing. They're not going to record it.
No, and you're not allowed to record it.
And their version of the facts is going to be the version that the court's going to buy into if this ever goes to court.
Well, and in fact, it becomes, you don't get to review the 302 until maybe after, maybe if you're indicted and you, under certain rules, you may get to look at it. But otherwise, you don't get to see what that 302 looks like. It's not like they send it to you to say, is this what happened? It's done. So the first rule is, if you're being interviewed, if you're approached
by the FBI,
and you are going to be interviewed by the FBI, many doctors will go, oh, well, if I ask for a lawyer, then, then it looks like I'm guilty of something. And so they don't want to ask for a lawyer.
And in fact, the FBI agent will say, well, you shouldn't have to have a lawyer if you don't have anything to hide.
Right. But, and here's the big but, you don't know what they're going to write. And frankly, there are many prosecutions. Lying to an FBI agent is a federal crime, and they will use as the basis of that lie the 302.
That's exactly right. In fact, all these folks we're here in D.C. right now, and all the folks in D.C. that have gone to jail with respect to the Russia collusion investigation, why'd they go to jail? Did anybody collude? No. Every one of them made a statement at some point.
Wait. I'm not sure I'm going to agree with the no.
Okay. But every one of them that currently has gone to jail it's been based on the fact that they supposedly have lied to the FBI or other investigators.
Well, whether they did or they didn't, and in those cases they may or may not have had better corroborating information. They were a pretty thorough bunch. But the real point is not Russia. The point is have a lawyer there who can also take notes.
And your lawyer may tell you, you know what, at this point, we're not going to put you up for an interview.
They may.
We're going to hold off.
That's right.
We want to find out some more what's going on because they're asking you questions that you're not prepared for. And there's a tendency in all of us, I guess, to be helpful.
Right.
And you may want to try to be helpful and may answer a question, and the government may come back later on and say, well, not only was it wrong, but we think it was purposefully wrong.
And the other thing is, what they say they're asking you about may be true, but they probably also have, or may well have, 3 other agendas that they're asking that you aren't even thinking about at all. And in an effort to be helpful, you're going to maybe guess, or maybe say, I think, or whatever. So have a lawyer there who can say, wait a minute, what are you asked? What's the specific question? Or when he hears the answer, he says, wait a minute, that doesn't sound like what you mean. He can help you out.
Yeah, it's very important. And just to kind of let you know, the FBI, keep in mind, you made the point, this is really important, you made the point that it's against the law for you to lie to the FBI, or to lie to an OIG agent for that matter. Okay?
Right.
It's against the law for you to lie, but it's not against the law for the government to lie to you. In fact, the FBI actually even has a policy saying when they can go in and act like they're not FBI, but instead pose as a media or documentary group.
I will say, though, if you lie to the FBI agent who's posing as a media group, that's not, I don't believe, going to be a federal offense, because it has to be a knowing lie to an agent in the course and scope of their offices, and you wouldn't know that. But just with that caveat,
you very well may make a statement against interest,
absolutely.
And you also may make a contradictory statement later on.
Absolutely.
And then the government's going to say, well, you lied to somebody.
Exactly. Now, you're on record, some record, for having in that conversation. No question.
Yeah, so the government can lie to you. And in fact, this has gone all the way to the Supreme Court, hasn't it, Paul? And the Supreme Court has, repeatedly affirmed that the government can lie to you, but you can't lie to the government.
Well, that's true, but that's been the case. That's in every state as well. The only time that the government can't you can't entrap you, but entrapment, even then, is a very tricky thing. They say if you had the propensity to commit the crime and they just gave you the opportunity, that's a legal thing. And there are 1,000 state law cases of dealing drugs or other matters in which entrapment is alleged, brought as a defense. Almost always unsuccessfully.
Now, there have been a couple of cases where the courts have said, you know what, in these particular situations, even the government can't lie that bad, okay? And those are cases where the courts have said it shocks the conscience. For instance, there was one case where a FBI investigator lied about who he was and told the defendant that he was the defendant's court-appointed attorney. The court said, no, that's over the line.
You think?
Yeah. Another one was where the agent posed as a clergyman to get a confession from the defendant. Once again, the court said, no, that's too far. So there is a bridge too far, but you have to really go far to get to it.
But let me say this. So, while the government, well, there are government lawyer or government investigators, FBI agents, whatever, who act in improper ways and will do things that are inappropriate and perhaps violate the law. But the fact is that we have to remember they're not all crooks. You and I were federal prosecutors,
right?
And you and I knew FBI agents who would never engage in that sort of activity.
And frankly, most of them wouldn't.
No.
And in fact, you're almost always, they're not going to hold it against you if you say, my lawyer says before I want to cooperate, but I need to call my lawyer before I can talk.
And that's the point that I was getting to. It's exactly the point, which is that what you want is that's one of the main reasons, because your lawyer, a good lawyer will help you sort through who you can say and what you can say and how you can say it, and make sure that what you say is the truth and is appropriate, and so that you can cooperate with them without being afraid of the words that you're using. And so that's really part of the importance of bringing in counsel of your own and dealing with the FBI, so that they can do the process. They have experience and they know which guys and gals they can trust, and which ones, I'm not so sure, I'm not going to let you, whatever.
That's right. That's right. So, at the end of the day, though, they can't force you to talk. And you can tell them at this point, I want to exercise my right to remain silent. Right. I want to talk to my lawyer. I want to cooperate, but I want to talk to my lawyer first.
I wouldn't even say I want to exercise my right to remain silent, because that's when you're ordered to in a court. Yeah. You just want to say, I want to talk to my lawyer. I just, look, you're probably one of the greatest, most straightforward agents in the world, yeah. But my lawyer but I trust my lawyer more than I trust you. Now, one thing that I have seen several times is situations where they said, well, I really don't want to talk. And the agent then says, oh, that's fine. That's fine. But could you just answer some very basic questions for me? Yeah, they'll do that.
They'll do it. And you want to be cooperative because you think you're a good corporate citizen. Yeah. So you have to be really careful. All right. So let's just kind of wrap things up then. We've talked a lot about the various types of kickbacks.
We're a few minutes over.
Yeah, and the business arrangements. You got to look at these things. You got to be careful if you're being asked to serve as a consultant or a medical director. If you're being asked to provide telemedicine services, please have your lawyer look at the agreement first. Okay, and just because the paper may say one thing, you have to also verify when you finally start doing whatever it is you're doing, that is exactly what's happening. Just because the paper may be clean doesn't mean that it's necessarily that's what's really happening in real life. And that's what happened with that telemarketing fraud case. The contract itself was set up so it was legal, but what they were doing was illegal.
Right. And my only thing that I would say is it's a good time. It's a really good time to reevaluate all of your relationships with everybody that you have, with your labs and everybody else, just to make sure, take a look at them, because a lot of your relationships could be 5-10 years old, and things change over time.
And make sure that you've got a compliance plan in place, and don't play games with credentialing. Okay, I know you bring in a new doc, and it takes months sometimes to get them credentialed by the government and the private payers, but you can't be billing for their services under somebody else's number unless certain requirements are met.
It's a pain in the neck when you bring someone in and they're not credentialed, but there are rules, and there is a way to deal with it. Medicare has a way. It's cumbersome that you have to. I forget what.
Depending on the facts, you may qualify for Incident 2.
Right.
A doctor can work Incident 2 another doctor.
Right. And if they've applied for credentialing, then there's a way to sort of hold that billing until
every payer is different.
Every payer is different, and it's cumbersome. But because it's cumbersome, don't ignore it, and then still for the first 6 months under somebody's number that it's not theirs, and then say, oh, I guess we better get around to it.
That's right.
That's a bad idea.
And when you're doing your reviews, as we talked about, look at where do you get your business from? Where do you send your business to? Because if you're ever audited or investigated, that's what the government's going to be doing. And that wraps it up for today, Paul.
Were there questions or no questions? You handled the questions, Andrew. Well done.
Excellent. All right. Well, guys, if y'all have any questions, always feel free to give me or Paul a call. Our phone number is there, and our emails are also listed. Thank you.